UC Davis Innovation Access Presentation, Intellectual Property and Technology Transfer. Contact information. Please forward all questions and comments of this presentation to David McGee at drmcgee@ucdavis.edu. Agenda. This presentation will provide general discussion and introduction to the technology transfer process, types of intellectual property, how inventions are handled, and what constitutes an invention, patents, copyrights and trademarks, how licensing of intellectual property is done, and finally, starting up companies. Introduction. University of California's principles for research results. The University of California, like all public institutions and most private institutions, share a mission of public benefit for research and education. The academic principles outlined below describe fundamental principles for which all research and all intellectual property and licensing must adhere. Above all, we must have open dissemination of research results and a standing commitment to students to make sure that their experience and education at the institution are carefully preserved, and to have agreements that provide fair legal provisions for both parties. Why is it important for California to patent and commercialize intellectual property? Because the mission of government agencies is not normally oriented towards commercialization, it is not always clear to those on the outside why we should be engaged in commercial activities such as patenting and licensing. At a university, inventions are usually early stage, basic research discoveries, and are not oriented towards a commercial product. Through patenting, we are able to attract licensees, that is, companies, who may be interested in providing the additional capital to take that early stage discovery to a commercial end product. In this way, the new invention arising from the university's research efforts is able to reach the public through a commercial outlet, whereas otherwise it would likely not be able to be made available because it would have required further development, which the university is not able to do. Multiple stakeholders. In technology transfer, there are many interested parties, both internal to the university and external. This requires a great deal of interaction, explanations, considerations, and otherwise to make sure that all of the interested parties have a say in how this is handled, have impact in the development of these new relationships, and that, above all, the public benefits. As you can see from this slide, many of these organizations do not normally work together, but through an effective technology transfer program, we are able to bring these parties together for the greater good. Confidential Disclosure Agreement, or as we call it, a CDA. The nature of intellectual property is that it is normally kept confidential until patent protection has been obtained or a patent application has been filed. For that reason, it is very common to have a CDA signed between the university and an interested party who may be a potential licensee. It's very important to have such a CDA in effect because without it, intellectual property rights through patenting are sometimes lost. For example, if a new invention is disclosed through publication or non-confidential conversation to another party, international patent rights are immediately lost. And in the United States, we have a 12-month grace period through which we then must file a patent application or U.S. patent rights will be lost. But through a confidential disclosure agreement, we are able to avoid the loss of patent rights due to disclosure, and that provides us time to discuss potential licensing and to prepare patent application. Technology transfer process. The technology transfer process outlined here typically involves new discoveries arising from a sponsored research project which includes government grants or grants paid for by private industry. The research typically results in new inventions. Those inventions are disclosed to the Technology Transfer Office, and if the invention is viewed as having patentability and commercial potential, the Tech Transfer Office will file a patent. Once filed, the new invention, now protected through a patent application while the prosecution is pending, can be marketed to potentially interested companies, leading to the possibility of a commercial license. How do we determine whether or not a research project will result in an invention that is commercializable? First and foremost, it must have public benefit. Public benefit can be made through simply releasing the invention without any patenting or licensing into what's called the public domain, in which case the university is able to make it freely available to anyone with no charge. However, as stated earlier, if the invention is going to require substantial capital to realize a final product, then public domain release is probably not the right path. Instead, patenting and attracting a licensee provides us with the necessary capital investment in that invention to provide a new commercial product that can then be sold to the public. The commercial potential evaluation, as listed here in the slide, is going to be involving the need for an invention, the strength of the intellectual property, meaning is this a clear, novel invention and meets all the patentability requirements? Are there competition arising in this area of intellectual property such that a new invention patented might be dominated or controlled by someone else's patent? How much will it cost to develop the commercial product, and how long will it take? Is the market that's being addressed by the invention substantial enough to warrant the expenses of filing a patent and prosecuting it, and to be attractive enough to a company so that they can make a fair profit? And how long is this product likely to last in the marketplace? Is it something that is likely to be improved around, such as simple software programs? Or is it something that may have lasting utility? And finally, do we have obligations to others, such as a industry sponsor or to the government, who may have paid for the development of the research that led to the invention and have third-party rights, as it's called? Steps towards commercialization of a research project. There are several steps that are fundamental in virtually any intellectual property that is derived from sponsored research agreements. It's therefore important to understand if there is third-party rights that has to be considered, such as government sponsorship or private sponsorship. Occasionally, the resulting invention is from in-house or universities' funds. This provides us with an ability to not have such third-party obligations. If there's a mixing of funds, then third-party rights can be more complex. Inventions must be disclosed in accordance with sponsored research agreement clauses. Frequently, an invention that is disclosed to the Tech Transfer Office under a sponsored research agreement must also be disclosed to the sponsor, and the sponsor then has an opportunity to evaluate the invention and decide whether or not it wishes to pay for patent prosecution through the university, leading towards a license. If the third party passes on that invention, then the typical language would allow the university to offer that invention to another party. We also have to look at market potential and how the public may benefit from either providing a license or not. The Tech Transfer Office will market that intellectual property, and if there is an interested licensee or maybe multiple licensees, we'll select that licensee based upon receipt of commercial information from the company or companies, and then negotiate a license agreement. Intellectual property. What is intellectual property? Intellectual property is defined as inventions or ideas that exist in intangible creations of the human mind. That means it's something that is generated within the brain of the inventor. That's why it's called intellectual property, or IP. Intellectual property is different than what's called real property, such as real estate. And it's different than personal property, such as automobiles, wristwatches, furniture, etc. For that reason, the protection of intellectual property has different legal considerations than real property and personal property. Intellectual property is protected under intellectual property laws. These laws relate to the various types of intellectual property, which are patents, copyrights, trademarks, and trade secrets. Interinstitutional agreements, or IIAs. Frequently, universities collaborate with other institutions, whether they're other academic institutions, nonprofit organizations, or companies. Interinstitutional agreements set forth terms that allow invention commonly owned between the institution to be shared and marketed and patented and licensed. Inventions. The Bayh-Dole Act of 1980 was an important federal law that allowed for the first time universities that were receiving federal funding and grants to elect ownership of inventions that arise from research. Prior to that, all inventions discovered with federal funds belonged to the federal government. With the advent of the Bayh-Dole Act, universities began to establish tech transfer offices to evaluate these inventions, to file patents, and to conduct licensing. This was a critically important act because it allowed for the first time universities to make the most use out of those new discoveries and to provide licenses to companies so that our inventions could have the best chance to reach the public. What is an invention? There are two general types of inventions, those that are patentable and those that are not patentable. The creation of a complete and operative idea is an essential component of an invention. Who is an inventor? An inventor is anyone who intellectually contributes to the enabling concept of at least one issued patent claim. It's important to distinguish between an author on a paper and an inventor. An author on a paper may have conducted research, but did not actually contribute to the enabling concept. On the other hand, an inventor may have come up with the concept, but not be an author on a paper. Inventorship, therefore, is a legal determination. Record of invention. The invention is recorded and first presented to the Technology Transfer Office using a form called a Record of Invention, or ROI. This form is available on our website. The Record of Invention provides a detailed description with full enablement of the actual invention. It also describes who it is believed to be the inventors. It provides important dates of invention, and it allows the University Tech Transfer Office to evaluate that invention for patentability and to determine marketability and whether or not it is likely that there would be an interested licensee. It's very important to remember that an ROI does not protect the invention. It is not the same thing as filing a patent application. Therefore, even though the ROI is kept in confidence with the Tech Transfer Office, the inventor should not publish the invention unless and until a determination has been made whether or not to file a patent application. Once that patent application is filed, then the inventor may be able to publish and provide a description of that invention. It's always good to check with the Tech Transfer Office prior to do so to ensure that the patent application has actually been filed. If the Tech Transfer Office has determined, along with consultation with the inventor, that a patent is not going to be filed, then the inventor will be free to publish without any concern because there will be no intellectual property to protect. Laboratory notebooks oftentimes provide an excellent source of the invention description, the date of invention, and who actually was the inventor. Therefore, clear, complete entries that are witnessed on a routine basis provide a useful invention record. Employee obligations. Make sure that you understand what obligations you have as an employee to your employer for all inventions. It's common under state laws for employers to have ownership of inventions made by an employee in the course of his or her employment. Make sure that you adhere to those policies and those laws by informing your employer about any intellectual property that you may have discovered during your employment. Outside activities by employees. The University of California does allow and in fact encourages outside activities by its faculty. One common form of such activity is consulting. Make sure that you understand your employer's consulting policy. At the University of California, policy allows 1 day per 7-day week maximum for consulting activities. The contract at the University of California for consulting is generally viewed by most schools on campuses as a personal agreement between that faculty member and the company. However, the faculty still has an obligation to disclose all inventions to the University of California Tech Transfer Office for those inventions that are discovered, whether or not they're at the university or with a consulting company or even at home. When disclosed, the Tech Transfer Office will make a determination in consultation with the inventor whether or not that invention may be owned by the university or whether it was discovered outside of the university's ownership. Please remember that consulting activities may constitute an employee conflict of interest, that is, a financial conflict of interest, and a conflict of commitment. Make sure that you understand these policies and feel free to ask your department chair or dean for further information. State government may have specific laws that apply to such consulting arrangements. Other types of outside activities may be prohibited or severely curtailed, such as a faculty member being a corporate officer or a member of the board of directors. Make sure that you read your university's policies and understand them. Patents. What is a patent? A patent is an exclusive right to the owner of the patent that is granted by the federal government under Title 35. A patent has a limited term of 20 years from the date the application is filed. It allows the owner of the patent to exclude all others from making, using, selling, offering to sell, or importing the claimed invention. What type of intellectual property is patentable? Basically, a process, a machine, composition of matter, or article of manufacture are patentable subject matter. A process may be a method or a series of steps for producing a product or result. A machine is an operable apparatus comprising a combination of elements. Composition of matter covers the actual compound or formula or mixture of ingredients. An article of manufacture is an object that is manufactured. Requirements for patentability. In order for an invention to be patentable, it must satisfy several criteria. First, the invention must be novel. It must be absolutely new. That is, no other prior art has ever done this. It must be non-obvious. That means the subject matter as a whole would not have been obvious to a person of ordinary skill in this field of science or art. It also must provide full enabling disclosure, that is, enablement. It is not permitted to leave out details that would be required to actually practice the invention. And in the United States, the disclosure must include the very best way of practicing the invention. In other words, trade secrets, certain elements that would actually make the invention better that are known to the inventor at the time of filing must be provided in the patent application. And finally, an invention to be patentable must be useful, and it must not be against public policy, such as a way to harm the public. Types of patents. There are three basic types of patents. The utility patent, which covers products and processes. The design patent that covers ornamental design, such as a new type of tennis shoe, a new ornamental design on clothing. A plant patent, which covers asexually reproduced plants. How does Innovation Access, the Technology Transfer Office at UC Davis, market new inventions? Well, faculty inventors are usually one of the very best sources of potential licensees because the inventors know what other institutions and companies are involved in this area of research. So we solicit such information from faculty. It proves to be one of our very best sources. The university also posts abstracts of new inventions for which we file the patent application on our Innovation Access website. In addition, we post these inventions on subscription websites that are commonly used by companies looking for new inventions to license. In addition, we try to identify companies that are working directly in this area of the invention, and we contact them. And then finally, we participate in trade shows used to find potential licensees. The types of utility patent applications. There are two basic types, the provisional patent application and the non-provisional patent application. The provisional application is typically filed when there are no claims required and securing the intellectual property rights for a temporary period not to exceed 12 months is desirable, such as when there is an upcoming publication or delivery of a talk, and there isn't time to necessarily do all of the marketing, commercialization assessments, and patentability. Provisional patents are typically shorter and less expensive, but not all of the time. The provisional patent application, however, is never examined by the Patent Office, and it's only good for 12 months, at the end of which the Patent Office automatically abandons that patent application. Therefore, prior to the expiration of the 12-month period, the provisional application must be refiled as a non-provisional patent application, which is the fully drafted and claimed patent application. Utility applications will be examined by the U.S. Patent Office. Filing, prosecuting, and maintaining patents, costs and timelines. Provisional patent can be filed for as little as a few $100s, but the cost can be substantially greater depending on the amount of effort put into the preparation of that patent application. So it could range up to $10,000. The typical non-provisional patent prosecution will take $10,000 to $20,000 or more dollars for preparation and prosecution to issuance. Foreign patent costs vary depending on the country in which the patent protection is sought, whether or not there are translation fees and other special fees. The typical cost of foreign patent prosecution in a dozen or so industrialized nations can be well over $100,000 to prosecute to issuance. Once patents issue, there are ongoing fees called maintenance fees and annuity fees to keep that issued patent current. The typical timeline for a U.S. provisional, as mentioned before, is 12 months, and then it's abandoned by the U.S. Patent Trademark Office. The U.S. non-provisional and foreign must be filed within 12 months. These are published 18 months after filing. And typical time to issuance is several years, although it can be much longer. U.S. patents are good for 20 years from the date of filing or the priority date if that new patent application has arisen from a previously filed patent. There are several critical deadlines that it's important to remember in order to preserve your patent rights. In the United States, a patent application must be filed within 1 year of any public use or sale or offer to sell in the United States. Anywhere else, any printed publication describing the invention can constitute a loss of patent rights. It's also important to know what are called bar dates and grace periods. These vary depending on the particular circumstance, and you want to consult your tech transfer office for more information regarding those. Freedom to operate, or FTO. This is a term that's constantly used, and it's presumed by many that a patent, once issued, provides freedom to operate for the owner of that patent to use the invention. It's important to understand that a patent does not provide freedom to operate to the patent owner or to a licensee. What it provides is a time to exclude others. That time limit may be as much as 20 years. But your invention that's covered by a patent may be dominated by someone else's patent. And you may need a license from that other patent holder in order to practice your own invention. Correspondingly, the owner of a dominating patent would not be able to practice your invention that might be subordinate to it without a license from you. So patents do not provide freedom to operate. They merely allow you to exclude others from practicing your invention, unless you provide a license. How to understand patent scope. This is a complicated area. The patent, once allowed and issued, provides claims that describe what the patent is actually covering. But in order to really understand what a patent scope is, or what those claims really cover, it's important to become familiar with the various parts of a patent. The cover sheet, the specification, which essentially is the text of the patent application, including the claims, those claims allowed, and correspondence between the owner of the patent during prosecution and the patent examiner. This correspondence is collected together in what is called a file wrapper, and that file wrapper is available from the patent office. That correspondence frequently provides much greater insight as to what the scope of the claims really are, what areas have been given up by the owner of the patent in order to get a patent issued. Therefore, it's critically important to look at file wrappers when trying to determine if an issued claim is as broad as it may appear to be. And then finally, court decisions regarding that patent and maybe others that impact your patent can be very important in terms of looking at your patent scope. Copyrights and trademarks. What is a copyright? Copyright is a federal statutory right granted to every author of a literary or artistic work that is expressed in a tangible medium of expression. Such examples are lines of computer code, text, music, and video. A copyright protects the expression of the work, not the content. For example, data itself is not copyrightable, but the expression of it in an article is. The copyright. The copyright provides the author the ability to exclude others from any of the following acts with the author's original work: reproducing it, modifying it, which is called creating a derivative work, distributing it to the public, publicly performing the work, publicly displaying the work. The copyright arises automatically to the owner when the work is made. Even if the copyright is not registered with the Copyright Office in the United States, there nonetheless is a copyright. However, registration of that copyright is important for certain procedural advantages. Trademarks and service marks. What is a trademark? Trademark is a word, a design, or phrase which is used by the owner to identify its product or services. Examples are Kodak, 3M, IBM. The more fanciful or coined, the stronger the mark. The primary purpose of a trademark is to differentiate a company's products from its competitors. What is a service mark? A service mark merely differentiates a company's services from its competitors, so it's similar to a trademark. Both trademarks and service marks may be registered with the U.S. Trademark Office. Trademark notice. When the trademark has not been registered with the Trademark Office, you can identify a trademark using the letters TM, or SM for service marks, in small caps, or a footnote which identifies the trademark and its owner, as indicated on this slide. Or a phrase such as RS6000 is a trademark of the IBM Corporation. There are three alternatives for registered trademark notice. You can type in registered in the U.S. Patent and Trademark Office, or abbreviate this, REG, US, PAT, and TM Office. Or once the trademark is registered, you can merely put a circle around an R. Licensing. How is a licensee selected? Well, at the university, a licensee is primarily selected from response to marketing inquiries. When we get a prospective licensee, the company has usually viewed our information on our website or through subscription-based websites, or perhaps we've contacted them directly because we have reason to believe that the company may be interested in our intellectual property. Many times, our inventor has provided a referral to that company. The commercialization plan from a prospective licensee is essential. This allows the Technology Transfer Office to understand what the licensee intends to do, when they intend to do it, and to ensure that they have a plan to not shelve that university's valuable technology. If there are multiply interested companies, then it allows us to do direct comparisons so that we have a better assessment of which licensee to select. In addition, as mentioned before, the Bayh-Dole Act has certain restrictions, such as favoring small U.S. companies and U.S. manufacture. So we consider the Bayh-Dole Act when we are looking for particular licensees. Startup companies provide a highly focused company to develop university technology. Established companies usually want to see a more mature, less risky invention, and usually are waiting to see proof of concept, prototypes, completion of clinical trials for drugs, and so forth before being interested. Therefore, startup companies provide a terrific opportunity to further develop the invention for commercial access. In addition, the licensee considerations may involve inventorship issues, particularly conflict of interest and conflict of commitment. Is our inventor somehow associated with that company that's interested in a licensee? Are they, for example, consultants to the companies that are interested? So the Technology Transfer Office will ask these questions and resolve these issues prior to licensing. One alternative that's popular among licensees is to secure an option agreement rather than a license at the beginning. The option agreement essentially takes that invention off the market so that the Tech Transfer Office is no longer marketing or discussing licensing with any other company. It's time limited, usually 6 to 12 months, during which the optionee is able to assess that invention and negotiate license terms with the Technology Transfer Office without fear that that invention could be licensed to someone else. License arrangements always provide milestones that the company intends to meet. These milestones are typically converted in the license agreement to what are called diligence provisions, such as when would a therapeutic drug enter clinical trials? When would first sales be expected? Are there certain financial obligations that the company intends to meet? And so forth. The diligence provisions provide a yardstick for the university to measure progress towards commercialization by the licensee and to allow us to have a better way to determine if the company has lost interest and maybe the technology is therefore being shelved. Failure to meet diligence provisions can result in default of the license and return of the invention to the university through termination of the license agreement. Marketing. The goal of marketing, first and foremost, is to increase awareness of the public of technologies that we can make available to them. Our target audience is both technical and business. We conduct market research, we ask inventors for information, and we look at databases. Today, with the advent of the internet, it's much easier to look for potentially interested licensees than used to be done with hard target manual searches through mailings and phone calls. However, the Tech Transfer Office still uses those technologies to ensure that we get as broad a coverage of our marketing activities as possible. Licensing. There are various types of licenses, and when negotiating with a prospective licensee, it's important to understand at the beginning what type of license are we willing to offer and what type of license does the licensee really need. Licenses may be exclusive or non-exclusive, relating to fields of use. In addition, geographic limitations may be imposed in a license. For example, a company may be operating only in Europe and have no capability to develop the invention and sell it in the United States. Frequently, licensees also want to be able to sublicense their rights to another company in exchange for revenue. So at the beginning, we like to look at what kind of license is really needed, and then we base our terms on that type of license. As mentioned earlier, there are alternatives to a license, such as an option agreement or an evaluation agreement. These do not provide license rights, but do provide a time-limited period for the potential licensee to look at the invention, to evaluate it, and to negotiate license terms. The advantage of doing these temporary agreements is that the cost to the licensee is less, but it doesn't provide license rights. But it does take the invention off the market for a period of time while the licensee assesses its needs and negotiates the agreement. This is particularly useful and preferred by many startup companies who don't have revenue at the time and where all the dollars really count. License fees and royalties. All licenses must provide the university with fair compensation for the invention. Through market analysis, through discussions with the licensees, and through experience by comparing the invention and license agreements with similar agreements and inventions, the university and the licensee negotiate financial terms. First and foremost, the university must get paid back any out-of-pocket expenses. Usually these are for patent costs that we've incurred prior to the license. Licenses also frequently have an upfront license fee. Maintenance fees refer to annual fees to keep a license current. Royalties are based predominantly on net sales of products sold. The royalty rates vary depending on the type of product, whether or not it's going to require substantial capital by the licensee to develop it for sales, and so forth. Royalty rates are usually lower also if it's a non-exclusive license. Sometimes licenses are going to be coupled with other license agreements that company may need for licenses that are not owned by the university, but which are required in order for the invention to ultimately reach commercialization. Combinations of royalties from various licensing organizations can create an overall total license royalty that can be prohibitive for the company to have commercial success. This is called royalty stacking. The university typically provides anti-stacking provisions in its agreements to help the licensee deal with situations when there are multiple royalties involved. Sometimes licenses also address advances against royalties, and the university will entertain such terms when it's appropriate on a case-by-case basis. University of California royalty policy. The University of California has a system-wide patent policy for distribution of revenue obtained from licenses. After recovery of patent legal expenses and other non-reimbursed expenses to the university, 35% of the net revenue is distributed to the inventors. 15% is provided to support research at the college, and the remaining 50% goes to the Chancellor's General Fund to help support education and research at the campus. Starting up companies. UC Davis has a long-standing, strong support of entrepreneurship. The Graduate School of Management has a certification program in entrepreneurialism for PhDs and postdocs and MBA students. It also provides business plan competitions called Little Bang and Big Bang, with substantial prizes to the winners of these contests that support the development of new company concepts by researchers and students. In addition, UC Davis provides commercialization analysis, networking, introductions, and business plan support to the university community that are interested in starting up companies. Faculty roadmap. Several years ago, the Faculty Senate at UC Davis requested that Innovation Access develop a website that would guide faculty entrepreneurs through the various considerations needed as a faculty inventor who's interested in starting up a company. This slide shows the first page of that website, and the website is listed at the bottom of the slide. The roadmap provides detailed analysis by clicking to lower levels of greater degrees of detail. All information, ultimately including UC policies, as to what's really required for a university professor to start up a company. UC Davis startups. UC Davis has been very successful, particularly since the development of Innovation Access in 2004, in encouraging new university startup companies. This slide shows the development and the breadth of different types of companies based on technical areas that have been started, particularly since 2004. As you can see, the university, because of its broad-based areas of invention and discipline, has resulted in a wide variety of types of companies, whether they're veterinary or agriculture, software, service companies, medically related companies, IT, engineering, and biotech. Information services. This slide provides websites for additional information to the interested technology transfer party on the outside or to our campus. Please feel free to access the Innovation Access website, the faculty roadmap, and to contact our tech transfer office with any questions at any time.